Welcome, everyone, to the Federal Bar Association Ketam Sections, The Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald. I am programming chair of the FBA Ketam section here with Tejinder Singh, who's a partner at Sparacino PLLC. This is our first episode in 2024. We've got a number of Court of Appeals decisions to talk about. Let's start by revisiting a case we discussed in 2023, U.S. ex-rel Heath versus Wisconsin Bell, Inc. This case involves a purported fraud against the telecom subsidiary program and whether that counts as fraud against the federal government. You and I discussed this, the original Seventh Circuit opinion, that was back in August of last year. And at the time, the appellate panel said it might be actionable under the FCA, but sent the matter back to the trial court to weigh various facts. So since we talked, Wisconsin Bell moved for rehearing, claiming the issue was actually a pure matter of law, and the panel agreed, issuing a revised opinion without rehearing. Still, I suspect, Tejinder, that Wisconsin Bell wasn't very happy with the outcome. Why so?
Yeah, this is an example of careful what you wish for. So the question on which the panel originally remanded, in addition to saying no summary judgment generally, was to say, are these claims that are actionable under the False Claims Act? So the program in question, the E-rate program, gets its federal funds through a sort of chain of sources. And so there was a question about, hey, is this the type of program that the FCA protects at all? And the panel originally said, well, the relators presented sufficient facts that would allow you to track some government funds into the program, and so they could be false claims. And in the rehearing petition, as you note, the defendant said, no, it's a pure question of law. All the facts are agreed. Just decide it. And the panel said, okay, we'll decide it. The relator is right. These are, in fact, federal funds. These are claims, and so the lawsuit can proceed on that issue as a matter of law. So, in one sense, Wisconsin Bell got its wish. In another, the issue was resolved probably in a way they didn't like.
Let's turn to our second case, U.S. ex-rel Johnson versus Raytheon Company from the Fifth Circuit. This is a reprisal case brought by a relator under Section 3730H, the anti-retaliation provision of the Federal False Claims Act. And here the relator alleged that Raytheon's retaliation led to a loss of his security clearance. That seems like it might be actionable, even though security clearance revocations usually aren't reviewed by our courts. For instance, Tejinder, in Radigan versus Holder, a seminal Title VII case from the D.C. Circuit, the D.C. Circuit said that the steps leading up to a revocation can potentially constitute retaliation, even if the revocation itself is outside the court's purview. But here the Fifth Circuit held that Radigan didn't apply. Why?
Yeah. So in this case, the relator was the employee was a employee of the defense contractor, and the contractor reported him to the Navy and said, hey, there's some issues here. This guy's committed some security violations. He was investigated, and eventually his top secret clearance was revoked as a result of that investigation. And he said, hey, the steps that you took against me are retaliation for my FCA related activity. And what the court says here is, so there's a decision called Egan that says, generally speaking, courts cannot review the revocation of a security clearance. You can't bring a tort claim based on they took away my clearance. And there's a separate question, which is whether the steps that an employer takes leading up to that can be actionable under employment statutes. And this Radigan case that you cite says, yeah, sometimes they can be. The court here distinguishes Radigan by saying what mattered there is that the employer initiated this process to try to get the clearance revoked, but it was ultimately unsuccessful. Here, at the end of the rainbow, the security clearance was revoked, showing that the employer's claim was meritorious. And so we're going to treat this case differently from the other. Now, I think that there are two potential implications you could take away. One, you could argue that this case stands for the proposition that what ultimately happens to the security clearance may end up being dispositive, or at least very, very relevant to whether a retaliation claim can go forward. Another way that you could think about it, though, is to say that you're going to focus, if you're the employee in this situation, what you want to focus on. That is, whether you want to focus on the ultimate loss of the clearance, which I think is problematic, especially in cases where it's ultimately revoked, or whether you want to focus on interim steps that may have collateral consequences for you other than revocation of the clearance. It does seem like under cases like Radigan, those could be independently actionable.
Next, we have U.S. XREL Hart versus McKesson Corp, fresh out of the U.S. Court of Appeals for the Second Circuit. This case deals with pleading standards for FCA cases that, based on the anti-kickback statute, violations occur, and specifically how the AKS scienter must be pled. The panel portrays itself as falling in line with most other circuits, Tejinder, but the actual text of its opinion could make it an AKS allegation pretty hard to sustain. The whistleblower here pled that he warned McKesson about its actions, but the panel seemed to require more than such notice. Tell us more about this.
Yeah, so there are two pieces here. The first is, what is the standard for AKS scienter, and the second is, what did the court do with this complaint? On the first point, the court says that in order to violate the AKS, you have to act knowingly and willfully, and the statute requires you to at least know or believe that your conduct is unlawful. You don't have to specifically think you're violating the AKS, but you do have to believe that your conduct, or at least have some general awareness that your conduct is unlawful in some way. It's not enough to know, for example, that what you are doing, and to know that kickbacks generally are prohibited. And the panel reasons that, the AKS is complicated, it's evolving, there are all these safe harbors, and it was not Congress's goal to impose criminal liability, because the AKS is foremost a criminal statute, on people who inadvertently pay some prohibited kickback. They have to at least know that their conduct was somehow unlawful. The relator argued for a broader interpretation, basically where if you know what you're doing and know generally that kickbacks are prohibited, you could be held liable. He cited this one Fifth Circuit opinion called St. Junius for that. But the Second Circuit dismisses that opinion as an outlier, noting that other Fifth Circuit decisions don't seem to have embraced its reasoning. There is a potential shallow circuit split here, but I think the Second Circuit does everything it can to kind of say, no, our view is the consensus view among the other courts. And there were three allegations that the relator said were important. The first you've already described. He said, well, I told people that I think some of the practices here violated the AKS. And the Second Circuit says that's not enough, because you don't also allege that anybody actually took you seriously or agreed with you. And so we can't impute your views to your company, even though you're an employee at the time. The second allegation was that in response to a civil investigative demand, the defendant destroyed certain documents and other materials that would have been relevant to the investigation. The Second Circuit says, well, that's not enough, because there's no evidence that they were covering up their conduct at the time they were doing it. And because we try to evaluate scienter based on your contemporary beliefs, not your later beliefs, what they did after the fact doesn't really speak to what they thought back then. And then the third set of allegations had to do with an email that was circulated, which said, hey, you didn't get this from me. And the Second Circuit, it talks about some of the allegations and policies that were allegedly kickbacks. And the Second Circuit says, well, that's not enough, because it was a really long email with a bunch of attachments, and the stuff about this was kind of buried. Now, I think what you see here is that the Second Circuit is refusing to do at the pleading stage what I think courts probably ought to do, which is draw inferences in a relator's favor, especially on questions of scienter, which almost always have to be proved using circumstantial evidence anyway. But it does throw up a bit of a caution flag. I think that from now on, relators will be well served by saying, not only, did I tell my colleagues that they were breaking the law, but they seemed to have very serious faces and they nodded when I said it, or, something like that to suggest that the message landed a little more. I don't know whether the Second Circuit's analysis of this complaint has a lot of broader implications. It may just be that they particularly didn't like this one case. It's a very fact-intensive analysis in its own way, but it is somewhat striking for how they poo-poo the allegations.
And it sounds as if relators should be pleading those types of facts in the complaint in order to even survive a 12b6 motion.
I think that's right. I think it's clear that in an AKS case, you necessarily must plead that the defendants knew their conduct was unlawful, and you have to provide some facts to back that up. Now, scienter allegations are not subject to Rule 9b, and so this can be, a little bit different from some other allegations in FCA cases, but I still think you need to bring some facts forward.
Our final case is from the Sixth Circuit, State Farm Mutual Automobile Insurance Company versus Angelo. And this deals with what relators can promise in FCA settlements and whether they can be held to such promises. Tejinder, it's reasonably clear that relators can't release defendants from a claim that is actually owned by the government. But here we have a very colorful history of kind of a tit for tat in the filings where in the end State Farm wanted the relator to ask prosecutors to dismiss the case. Was that enforceable according to Judge Clay?
It was. So in this case, the litigation actually started with State Farm going after the relator. So it sued him under the RICO Act for big time insurance fraud. The relator apparently filed something like 348 counterclaims. He reached a settlement with State Farm and dismissed, the first 347. But his 348th claim was a sealed FCA action where he alleged that State Farm was taking certain actions that caused the government to have to pick up the tab for certain health care that State Farm wasn't paying for. And so the question then was, could the relator release that claim? In general, the False Claims Act provides that an action may only be dismissed with the consent of the government once it's filed. And so there's a question that a lot of courts have addressed in various different ways about whether and when relators can release an FCA claim that's already been filed. Here, what the district court said was, first, okay, I can't force you to release the claim and I can't just get rid of the claim, but I would order you, relator, to go to the government and in good faith ask them to consent to releasing the claim. And if they say no, then they say no, that's fine, but you have to go and in good faith ask. So the relator's lawyer makes a phone call and he tries to do this, and then the government says, no, we're not consenting. So then they go back to the district court, and the district court says, the State Farm says, look, you didn't really try in good faith. You made some misrepresentations to the government about the nature of the requested dismissal. Like, you didn't even say that you wanted it. So you gotta, instead, court, can you please just order this guy to file a motion to voluntarily dismiss the action, and then subject to the government's written consent, that motion can be granted. So the relator then files the requested motion. In the meantime, a co-relator jumps in, which it turns out is probably controlled by the original relator. And he says, oh, but that you can't dismiss their claim. And so there's like a little more back and forth. But eventually, ultimately, the government consents to the dismissal, it goes away. On appeal, the question is this allowed? And the Court of Appeals basically says, yeah, it is. Although there is a policy that in certain circumstances will stop a relator from dismissing a qui tam action. So for example, a pre-filing general release will often be held to be unenforceable, especially if the government doesn't know about the fraud. Post-filing releases can be held to be unenforceable if the government does not consent to the dismissal. In this case, all of the purposes of the False Claims Act have been properly served. The government knew about the alleged fraud. It ultimately consented. This is fine. It's okay.
So let's take a broader view. How does the State Farm case add to our understanding of the national state of play here?
Yeah, so there have been cases in a lot of jurisdictions where releases have been issued in a variety of contexts. So one context where you see a lot of releases is at the end of an employment relationship. Someone is leaving, they're being terminated, perhaps they're being offered a severance, and in exchange, they're to issue a release. And often that will be a general release. Sometimes it will include specific categories of claims. Those sorts of releases, as I described earlier, are treated a little bit differently, I think, from releases like this one, where there's pending litigation between the parties, and the relator wants to settle a lawsuit against him, and in exchange, he's giving up counterclaims. It's sort of a different vibe. So there is a variety of factual contexts in which this arises, where the considerations can be slightly different. The Court of Appeals opinion in this case actually does a pretty good job of canvassing like various circuit authorities and different fact patterns and explaining like, oh, here's why these considerations don't apply, here's why these considerations do apply, and why ultimately this is okay. But I think that it will vary quite a bit circuit by circuit how robust the law is on these questions and exactly what it says in terms of whether a release is enforceable. It's also going to be a highly fact-sensitive inquiry, turning on whether the government knows what's going on, whether the release is sought pre or post filing of the lawsuit, whether the relator is receiving something of value in exchange for the release. All of these can be really significant factors that courts are considering.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association Key Tam Sections, The Rounds FCA News with Tejinder Singh. We'll see you next time.